So in this model, we're going to talk about Nurse Practice Act, nursing regulation, and nursing care models. Overview of Nurse Practice Act, NPA. We're going to look at development and purpose of Nurse Practice Act. And on my slide, it says the Nurse Practice Act is enacted by state legislator to regulate nursing practice. It defines nursing roles, scope of practice, license requirements, standard, and disciplinary grounds, ensuring public safety and competent care. Each of the U.S. state, territory, and certain jurisdictions have their own unique Nurse Practice Act tailored to local needs. So who developed the nurse? Who develops and update the Nurse Practice Act? The legislators develop and update the Nurse Practice Act. Each U.S. state and territory has its own, as I mentioned before, passed as a law. Updates are usually made through legislation, often based on recommendation from the State Board of Nursing. Now, who is responsible for implementing the Nurse Practice Act? The Board of Nursing is responsible for implementing, regulating, and enforcing the Nurse Practice Act. The board licenses nurses. They investigate complaints, take disciplinary action, develop administrative rules to interpret the law. What is the purpose of the Nurse Practice Act? The purpose of the Nurse Practice Act is to protect the public by ensuring safe and competent nursing care. It defines the scope of nursing practice, set qualification for licensure, establish standard for nursing education and practice, provide legal authority for the Board of Nursing to oversee nursing practice. What are the key elements or information can be found in the Nurse Practice Act? So some key elements typically include definition of nurses' roles, such as the RN, LPN or LVN, and APRN. Scope of practice for each type of nurses is also type of information that you can be found in Nurse Practice Act. License requirements such as education, exam, and renewals, standard of conduct and professional behavior, grounds for disciplinary action, responsibilities and power of the State Board of Nursing, and then of course continuing education requirements. There are 59 Nurse Practice Act in total, one for each U.S. state and territory. Here is the breakdown. So 50 U.S. state and 5 U.S. territory. For example, Guam, Puerto Rico, U.S. Virgin Island, American Samoa, and Northern Mariana Islands. District of Columbia, like Washington, D.C. And additional jurisdiction include with their own regulatory authority or some military or federal system as well. So roles and responsibility of the State Board of Nursing. Implementation of the Nurse Practice Act, as I mentioned. The Board of Nursing enforces the Nurse Practice Act by licensing nurses, approving education program, investigating complaints, and taking disciplinary action to ensure public safety and professional standard. Who is the Board of Nursing? The State Board of Nursing is a regulatory body established by the state law to oversee the practice of nursing within a specific U.S. territory or a state. Its primary role is to protect the public by ensuring that nurses provide safe, competent, and ethical care. The primary mission of the State Board of Nursing. Their mission of the State Board of Nursing is to protect the health, safety, and welfare of the public through regulation of nursing profession, or through the regulation of the nursing profession. This is done by enforcing the Nurse Practice Act, ensuring all qualified individuals become licensed nurses, setting standard for nursing education and practice, licensing and regulation. The Board of Nursing is responsible for issuing and renewing nursing license, such as the RN, LPN license, LVN license, and APRN. Reviewing qualifications such as education, like the NCLEX exam results, background checks, etc. Approving nursing education program in that state. Setting rules and regulations that clarify and support the Nurse Practice Act. Monitoring continuing education requirement. Disciplinary matters and action the nursing board can take. So these include if a nurse violates the Nurse Practice Act or behave unethical or unsafely, the board has the authority to take disciplinary action. The process usually involves investigation, hearing, and sanction. Possible action the board can take: warning or reprimand, fines or civil penalties, probation with specific conditions, license suspension, license revocation, permanent removal, or refusal to renew or issue license. Possible reason for license disciplinary action or sanction: substance abuse or impairment while practicing, negligence or unsafe patient care, falsifying patient record or documentation, criminal conviction, especially felonies or offense involving dishonesty or harm, violation of professional boundary, example, sexual misconduct, practicing without a valid license, and failure to meet continuing education requirement. The NCLEX exam and the National Council of State Board of Nursing. Roles of the NCSBN in NCLEX development. The National Council of State Board of Nursing is a non-profit organization that develops and writes the NCLEX exams. Essential for nursing license in the U.S. and Canada. Established in 1978, it represents the nursing regulatory body across all U.S. states, territories, and Canada. Its mission is to advance regulatory excellence to ensure public protection by supporting Board of Nursing and regulating safe and competent nursing care. Beyond exam development, the National Council for State Board of Nursing conduct research, promote licensure, portability, provide education resources, monitor nursing trend, suspend international regulation, and maintain license database. So what organization develop and write the NCLEX exam? As I mentioned, the National Council of State Board of Nursing, the NCSBN. They develop and write the NCLEX. What exam must graduate nurse pass to be licensed? The graduate nurse must pass the NCLEX RN for registered nurse or the NCLEX PN for practical vocational nurses to obtain their nursing license in the U.S. or Canada. So who is the National Council for State Board of Nursing? They are a non-profit organization that represent nursing regulatory body, the Board of Nursing, in all 50 states, including Washington, D.C., for the U.S. territory, Canada. It was formed in 1978 to assist state board in ensuring public health and safety through effective nursing regulation. What is the mission? To advance regulatory excellence for public protection. This means the National Council for State Board of Nursing works to support Board of Nursing in regulating nurses to ensure safe and competent care of the public. What are the other roles and functions of the National Council of State Board of Nursing? Besides developing the NCLEX and the NCSBN, also conduct research to guide evidence-based regulation and nursing practice, develop national exam and assessment, such as the NCLEX, RN, and PN, promotes license portability, example, nursing license compact, provide resources and education for nursing regulatory or regulators, such as educators and nurses, monitor trends in nursing practice and education, support international regulation effort, maintain database like the nurses for licensure verification and disciplinary action reporting. So, nursing care model, functional nursing. Functional nursing is a task-oriented care model where nurses are assigned specific tasks instead of holistic patient care, such as medication administration or dressing change. So now we look at functional nursing. As I mentioned, is a task-oriented model where each nurse or healthcare worker is assigned specific tasks. Example, one nurse gives meds, another changes dressing, and so forth, rather than caring for the whole patient. Advantage of functional nurses: efficiency, use of staff during shortage, is cost effective, tasks are completely quickly, and maximize use of unlicensed personnel. Some disadvantage of functional nursing: fragmented care, lack of holistic view of the patient, poor communication between staff, decreased patient satisfaction, risk of overlooking the patient needs. So nursing care model, team nursing and primary nursing. Team nursing is collaborative care model. Team nursing is a collaborative approach led by an RN where team members and share patient care responsibility. So, as I mentioned, the definition of team nursing involves a team of nurses led by an RN who works together to care for a group of patients. Each team member has a specific role, but the team shares the responsibility. What is the advantage? Collaborative, team-based approach, encourage delegation and leadership, is more holistic care than functional nursing. Good for inexperienced nurses to learn. The disadvantage is requires strong leadership and coordination. Communication issue may arise. Inconsistent team member can disrupt care continuity. In primary nursing is one RN is responsible for the patient care 24/7 throughout their stay. Associate nurse provide care when the primary nurse is off duty, following their plan. Some disadvantages are strong nurse-patient relationship, high continuity, and quality of care. It also improves communication and accountability, enhances nurses' autonomy and satisfaction. Some disadvantages of being primary nursing is costly due to higher RN staffing, may not be practical in short staffing setting, require experience and skilled RNs, high RN burnout potential with heavy caseload and primary nursing. Total client care nursing, the case method. One nurse provides all aspects of care for one or more assigned patient during their entire shift. This model is common in critical care. The advantage is high quality and holistic care, better patient satisfaction, strong nursing accountability, clear communication with patient. Some disadvantage is very labor intensive and costly, require a high number of RNs, may be inefficient if not well coordinated, and not sustainable in high volume unit. So in this case, nurse burnout is one of the disadvantages. Managed care and health insurance basics. What is managed care? Managed care is a healthcare delivery system designed to control costs, improve quality, coordinate care. It involves a network of providers who agree to offer services to members at reduced cost, often with focus on preventive care and resource use. So some key features of managed care include use of primary care provider, or the PCP, as a gatekeeper, and an emphasis on preventative care. It requires a pre-authorization for certain services and care provided through a network of approved providers. Cost sharing mechanism like co-payment and deductible focuses on utilization review to avoid unnecessary procedure. What is health insurance? So health insurance overview. Health insurance is a contract between a person and an insurance company that helps pay for medical and surgical expense. It reduces the financial burden by covering or reimbursing cost of the healthcare services. So Medicare, for example, is a federal health insurance for people 65 plus, certain young disabled individual. Eligibility is for age 65 plus and certain disability or end-stage renal disease. Coverage is for patient. Hospice will possibly have Part A, so like coverage is for patient. Hospice will possibly have a Part A Medicare, and medical series for Part B for prescription drugs. Patient will have access to Part D for the prescription drugs, and others. So this is a federal. These are the federal funded. These are all federal funded. And then Medicaid is a joint federal and state program for low-income individuals, families. This is income-based. It varies by state, and it varies by state includes such as hospital, doctor visit, long-term care funded, and of course it's jointly by the federal and state government. So it varies by state when it comes to hospital, doctor visit, long-term care funded jointly by federal and state government. Next, we look at case management in healthcare. First, what is case management? Case management is a collaborative process that assesses, plans, implement, coordinate, monitor, and evaluate options and services to meet a patient health need, promoting quality and cost-effective outcome. Case managers is a healthcare professional, often a nurse or a social worker. They coordinate patient care by assessing their needs, planning their services, facilitating communication among provider, patient, and family, and they monitor the progress as well. Ensuring appropriate use of resources. What type of patient benefit from case management? So patients who benefit from case management include patients with chronic illness such as diabetes or heart failure, those with complex medical need, patient requiring long-term care or rehabilitation, patient with multiple providers or services, high-risk patient needs frequent monitoring. So individual with multiple providers or services, such as high-risk patient, need frequent monitoring. So case managers help to coordinate and collaborate care and maintain the continuity of care by utilizing outside and internal network services. Some benefit of case management, as I mentioned, improve coordination of care, reduce hospital readmission and length of stay, enhance patient satisfaction and outcome, cost saving by avoiding unnecessary services, better access to community and support resources. And then some disadvantages of case management can be time consuming and labor intensive, require skilled personnel, increasing costs, possible communication breakdown if poorly coordinated, may face some resistance from patient or provider reluctant to change care plan. It depends on effective information system as well. Role of nursing organization and ethical principle in nursing. So role of the American Nurse Association. The American Nurse Association is a professional organization that represents registered nurses in the United States. It plays a vital role in setting standards for nursing practice, advocating for the profession, and promoting high quality care. Two main documents developed by the American Nurse Association include the Code of Ethics for Nurses. This is a guide for ethical decision making and professional conduct. The nursing scope and standard of practice. It defines the who, what, where, when, why, and how of nursing practice. And then National Association of Licensed Practical Nurse, NALPN, represent licensed practical vocational nurses. It supports their professional development, education, and role in healthcare system. Two main documents developed by the NALPN: the Standard of Practice for Licensed Practical Nurse or Vocational Nurse, which outlines expectation and competency for LPNs and LVNs, as well as the Code of Ethics. It's a framework to guide LPNs' moral and professional behavior. Next, we're going to look at nursing advocacy. This is supporting and standing up for patient rights, safety, and well-being. Some example include speaking up if a medication does not seem too high, helping a patient understand their treatment option, ensuring informed consent is obtained, and reporting unsafe practice or condition. Roles of the National Association of Licensed Practical Nurse. And we went over this already, but we'll do it again. So the NLPN is a professional organization representing licensed practical and vocational nurse. Support for professional development, offers resources, education, and advocacy to advance LPN career. Define the scope of practice, outlining the legal and professional boundary for LPN. Establish standard of practice, sets professional guidelines ensuring quality nursing care by the LPN. The American Nurse Association, the ANA, is a professional organization that represents registered nurses. In the United States, it plays a vital role in setting standards for nursing practice, advocating for the profession, and promoting high quality care. Two main documents that is developed by the ANA is a Code of Ethics for Nurses. It's a guide for ethical decision making and professional conduct. Nursing scope and standard of practice defines the who, what, where, when, why, and how of nursing practice. And I mentioned the National Association for Licensed Practical Nurse represent licensed practical vocational nurse. It supports their professional development, education, and role in the healthcare system. The two main documents developed by the NALPN is Standard of Practice for Licensed Practical Nurse or Vocational Nurse, which outline expectation and competency for LPN, and the Code of Ethics is a framework to guide LPN moral and professional behaviors. Of the National League for Nursing, the NLN is a major organization focused on nursing education and the development of nurses educators. Its role include accreditation of nursing education program via the CNEA, professional development for nursing educators, research and assessment in nursing education, development of educational standard and curriculum guideline, advocacy for nursing education, policies and difference between scope of practice, standard of care, or standard of practice and standard of care. So difference between scope of practice, standard of practice, and standard of care. Scope of practice. The legal boundary within which a nurse can practice based on state law and licensure. And then who define it? State Board of Nursing. Example, an RN can administer medication, and LPN may be limited in IV therapy based on state law. Standard of practice. Authoritative statement about competent level of practice by the nursing profession. So, who defines it? Professional organization like the ANN. Example, assessment, diagnosis, planning, intervention, evaluation, part of the nursing process. So that's standard of practice. Standard of care, a legal guideline representing the minimum acceptable level of care in nursing. The nursing organization and legal precedent or court defines this. Examples include failing to monitor a post-op patient vital sign regularly may breach the standard of care. Ethics, morals, values, definition, and differences. Ethics, rules provided by an external source, example, code of conduct in profession. Morals, personal principle about right and wrong, internal compasses, for example, your internal compass. Values, core belief or standard that guide behavior and decision. So the difference is ethics is societal professional rules, while moral is personal beliefs. And then values underline belief guidelines guiding the moral and ethics. So values underlines beliefs guiding moral and ethics. So nursing organization that focus on ethics is the American Nurse Association, the International Council of Nurses or the ICN, and National Association of Licensed Practical Nurse, the NALPN. American Nurse Association focus sets national standard for nursing ethics, practice, and advocacy in the U.S. Some key contribution it develops by the ANA Code of Ethics for Nurses, foundational guide for ethical nursing conduct, promote nursing advocacy, human rights, and social justice, provide guidance on ethical issues such as end-of-life care, patient autonomy, informed consent, and workplace ethics. The International Council of Nurses focus on a global federation of national nursing associations committed to ethical and quality nursing care worldwide. Some key contribution for them is they published the ICN, the International Council of Nursing Code of Ethics for Nurses. This is used internationally. Promotes global health equity, ethical standard across culture, human rights, and professional integrity. Ethical areas addressed in this: responsibility to people, practice, profession, and society, respect for diversity, and cultural sensitivity in care. So the National Association of Licensed Practical Nurse focus on supporting the licensed practical nurses and the licensed vocational nurses in the U.S. Advocate for professional and ethical practice, specifically to LPNs and LVNs. Provide code of ethics for LPN, focus on patient dignity and rights, competent, safe, and legal practice, accountability, and honesty in care. They also offer continuation in education, policy advocacy, and support for ethical decision making in practice. Ethical theories in nursing. Utilitarianism, teleological, excuse my pronunciation. This focuses on consequences, the greatest good for the greatest number. Example, allocating limited resource to save more life. And then deontology, focusing on duties and rules. Actions are morally right if they follow ethical rules, based on intention, not outcome. And then Kantianism by Immanuel Kant, a form of deontology that says action must be done from duty, guided by universal moral law. Examples: always tell the truth, no matter the consequences. Then looking at some ethical dilemmas. Ethical dilemma is a situation where a nurse must choose between two or more moral acceptable or unacceptable option. When it arises, when values or conflicts. Example: a patient refused life-saving treatment for religious reason. So ethics committee, what is it? They're a group that helps resolve ethical issues in healthcare setting. Members may include members such as a physician, a nurse, a social worker, a chaplain, a legal advisor, or a community representative. Their function is to review complex ethical cases, provide guidance to staff and families, develop policies, and educate staff. So when do we involve the ethics committee? When there is a conflict between a patient wishes and provide a recommendation. When end-of-life decisions are being made, and when informed consent is questionable or questioned. Ethical principle in nursing. So autonomy. Autonomy is respecting a patient's rights to making their own decision. Non-maleficent is to do no harm. Accountability is being answerable for your action. Beneficent, doing good and promoting well-being. Justice, fair and equal treatment. Veracity, telling the truth. And fidelity, keeping promise and commitment. So, non-maleficent versus beneficent. Non-maleficent, avoid causing harm, not giving a drug that may harm a patient, for example, while beneficent is promoting good. So, recommending a therapy that will help improve the patient's health. And then we look at veracity versus fidelity. Telling the truth is veracity. So example include informing a patient honestly about a diagnosis. And then fidelity is keeping one's promise, staying loyal. So this is following through on a commitment to call a patient's family. Non-maleficent obligation, as I mentioned, to do no harm. You want to avoid action that could cause injury or suffering. Not prescribing a drug with harmful side effect unless absolutely necessary is an example. Beneficent, obligation to act in the patient's best interest. Promote well-being and health. So recommending a therapy that helps improve quality of life, even if mildly uncomfortable, in the long run is going to benefit the patient. And then non-maleficent, focus on avoiding harm, and beneficent, emphasize doing good. The difference between veracity and fidelity. So veracity, as I mentioned, is duty to be truthful and provide accurate information to the patient. Example, disclosing a diagnosis honestly, even if it's bad news. You want to be very honest. And then fidelity is duty to be faithful, keeping your promise, upholding the truth, and professional obligation. Example, following through on a care plan or promise made to the patient. And what is ethical dilemma? When would one arise? An ethical dilemma occurs when healthcare provider faces a situation where two or more ethical principle conflicts, and choosing one may compromise another. So conflicting values, example, autonomy versus beneficent, legal versus ethical obligation, family versus patient wishes. So a terminal ill patient refused food or treatment, but the family wants everything done to prolong that person's life. A minor requests contraception without parents' involvement. So these is example of ethical dilemma. And then, of course, we have what is an ethic committee. Ethic committee is a multidisciplinary group in a healthcare organization that help address complex ethical issue in patient care. And as I mentioned before, this is made up of a physician, a nurse, sometimes a social worker, hospital administrator, legal advisors, chaplain or spiritual care provider, and members of the community or the community. So the function of the ethics community or the ethic committee is consultation. They advise staff, patient, or family on difficult ethical decision. Policy development as well. They help create institutional policy on ethical issues, end-of-life care, and informed consent. They also educate. They provide training and ethical awareness for healthcare staff. They look at conflict resolution, mediate dispute between family members and staff or among healthcare providers. So when would you get the ethics committee involved? So an ethics committee should be consulted when there is uncertainty or conflict about what is ethically appropriate. A patient's rights and preferences are in conflict with medical judgment. There are disagreement between a patient and a provider, for example, family and a staff, member of the care team. So some issues involve end-of-life care or withdrawal of treatment, informed consent or refusal, resource allocation, and then religious or cultural concern in treatment. Legal concept and law relevant to nursing practice. Types of law in nursing practice. We have constitutional law. This is based on the U.S. Constitution, which is the highest authority for citizens' rights and government power. So example, freedom of speech. We have statutory law or legislative. Laws created by a legislative body, example, the federal or state statutes governing nursing practice. Then we have administrative law, regulatory as well. Rules may be agency like State Board of Nursing to implement statutes, for example, scope of practice and rule. We have common law, judge-made laws derived from court decision, legal precedents often guiding standard of care in malpractice, so common law. Criminal law deals with crime against the state, example, assault, misuse of controlled substance, with penalties such as fine or imprisonment. Next, we have civil law. This is concerned dispute between individual or organization, typically resolved with damages, for example, negligence suits. So it's a concerned dispute between individual or organization, civil law. Next, we have contract law, governs agreement between parties or two persons. Nurses implement contract or consent form, enforceable through contract elements. So constitutional law is derived from the U.S. Constitution or state constitution, establish structures of government and define fundamental rights, protects individual rights, freedom of speech, due process, equal protection, set limits and government power. So an example would be law banning political protests is struck down as a violation of the First Amendment. And then statutory law is law written and passed by the legislative body, such as Congress or state legislative. It provides specific rules on issues like public health, education, or criminal behavior. So the example would be the Affordable Care Act is a federal statute that governs health care policy. And then for the administrative law, rules and regulation created by government agency like the FDA, OSHA, or CMS. These are agency. These agencies have power given by status to regulate specific industry. So some key function is enforce standard, issues license, conduct investigation, and impose penalty as well. And then for example, like the CDC issues guideline during a public health emergency. Nursing license are regulated by the state board under administrative law. So next we look at common law, like case law. Law developed by court decision, not written in status. It's based on precedents, like past judicial ruling. So it's based on past judicial ruling. Some key function guides how law are interpreted and applied in future cases. Provide consistency in judicial decision. And the certain example is a court ruling on malpractice case become precedent for similar cases. And a past judicial ruling. So then criminal law is law dealing with offenses against society. So prosecuted by the government. The goal is punishment by jail, fines, or probation. So for example, defendant is presumed innocent until proven guilty. Include misdemeanor, which is less serious, and felony, which is serious crime. An example, assaulting a nurse in a hospital could lead to a criminal charge like battery. And then civil law. What is it? This is law governing dispute between individual or organization, as I mentioned. The goal is compensation or resolution, not punishment. Some key involves private rights like property, contract, family, and injury. The injured party, such as a plaintiff, sues the defendant. So an example is a patient sues a hospital for negligent or malpractice in a civil court. And then contract law governs legal binding agreement. This is a binding agreement between two or more parties. Ensures that promises are upheld in the contract. Addresses breaches, also highlight enforcement and remedies. So an example is a nurse signs an employment contract with a hospital. If either party breaks the terms, the contract would then go into implementation. The contract would apply. So legal doctrine and staffing in healthcare. Respondent superior. Respondent superior let the master answer. For example, employers are legally responsible for employees' action done within job scope. And then captain of the ship. Physician liability as captain of the ship. Physician may be liable for all activities in their operating suite, even if performed by others. Then we look at borrow servant doctrine. So when a nurse is loaned to another entity, legal responsibility may shift to the borrowing institution. So responsibility shift via servant doctrine. So liability shift to the borrowing institution when a nurse are temporarily assigned elsewhere. And then compliance with staffing requirement. So hospital must comply with state mandate nurse to patient ratio and oversight via Board of Nursing Regulation. Nursing home require minimum registered nurse hour, on-site nursing, and adherence to federal state quality standard. Patient amendment occurs when a nurse ends the shift patient relationship without proper notice or transfer of care. And then, as I mentioned, I just go over again, responding superior. This is otherwise let the master answer. It's a legal doctrine that holds employers legally responsible for the action of the employee performed within the scope of their job. So a nurse gives the wrong medication due to a mislabeling issue. The hospital may also be held liable because the nurse was acting within their role. Why it matters. It protects individual nurses from full liability, but also encourages hospitals to properly train and supervise staff. And then captain of the shift. This doctrine states that lead physician or surgeon in a surgical setting is ultimately responsible for all aspects of care in the operating room, including the action of nurses and other staff. So, example, if a nurse make a mistake during surgery, the surgeon could be held legally accountable as the captain of his ship. So, controversy to do it is being challenged and used less today, especially when hospital not physician employed nurse. So borrowed servant doctrine, if an employee like a nurse is temporarily under the control of someone other than their usual employer, the person directing the nurse work can be held liable for errors. So an example, a nurse working under a temporary supervisor for another unit following incorrect order. That supervisor or department may be held liable under the borrower servant doctrine. So important for like float nurses or agency nurses working under different team leader or setting. And then staffing requirement, so legal and regulatory standard that define safe nurse to patient ratio, skill mix, and staffing levels levels needed to ensure safe quality care. So some example, California law mandate nurse patient ratios, so for example 1:5 on med-surg, and then Joint Commission on the CMS Center for Medicaid Services requires staffing to match patient acuity. So why does it matter? Inadequate staffing can lead to errors, burnout, and patient harm. May be used as a defense in malpractice claim. Patient abandonment. So what is it? When a nurse terminates the nurse-patient relationship without reasonable notice or proper handoff, leaving the patient without necessary care. So example of abandonment is leaving the unit during the shift without telling anyone, or refusing to care for a patient after accepting the assignment without transferring it appropriately. So what is not abandonment? Refusing unsafe assignment is not abandonment before accepting them. Leaving after giving appropriate report at shift change. So legal consequence may result in disciplinary action by the Board of Nursing or even loss of license. So respondent superior, employer responsible for employee action. So employee would be the hospital, for example. Nurse error while on duty. And then captain of the shift is the surgeon responsible for OR action, like the lead surgeon. So nurse's error doing surgery. And then borrow of servant liability shift to temporary supervisor directing the care. So agency nurse follow team temp leader orders. So the nursing agency follow temp order. So assume temporary liability shift to temporary supervisor. And then staffing requirement, law regulation for safe and staff levels, facility accountability, unsafe ratio lead to patient harm. And as I mentioned, patient abandonment is the nurses leaving the patient without care. The nurse is accountable. and leaving mid-shift without not reporting that he or she have left the shift. That is patient abandonment. Now we look at tort law, negligence, and malpractice. So tort law is civil wrong leading to a personal injury or loss. There are three types of torts. You have intentional tort, example, battery, unauthorized touching, defamation. This is false, harmful statement. Strict liability, responsibility regardless of fault, such as defective medical devices. And then we have negligence, harm from breaching duty of care, example, forgetting a safety check. So this is intentional. Then you have negligence, legal concept. 4 elements require duty of care, breach of duty, causation, and injury relating to the damage. So this is negligent and the legal concept with 4 elements: duty to care, breach of duty, causation, injury, and damages. And I will go in more detail with these as well. So malpractice, professional negligence by a licensed professional causing harm while performing duty. So malpractice versus negligence versus malpractice. All malpractice is negligence, but with professional client relationship context. Reducing nurse liability, so accurate documentation, proper delegation, and patient education. Following policy, clear communication, and timely reporting. So reducing nursing liability, how do we do it? Accurate documentation, proper delegation, patient education. Following policy, clear communication, and timely reporting. So as I mentioned, tort law is a breach of civil law that deals with wrong or injury caused by one person to another. Its purpose is to provide relief, usually relief to the injured party. There are 3 types of tort law, as I mentioned: intentional, willfully act that violate another's right, for example, assault, battery, false imprisonment. We have quasi-intentional. So this is act that cause harm without intent but involve violation of rights, for example, breach of confidentiality and defamation. And then we have unintentional tort. This is accidents or failure to act with proper care, for example, negligence and malpractice. Negligence is the failure to act with the level of care that reasonable, prudent nurse would use under similar circumstances. So the elements of negligence includes the duty the nurse has or had a responsibility to the patient, and then the breach of duty, the nurse failed to meet the standard of care, and then the causation is the breach caused harm to the patient, and then of course damages, the patient suffer actual harm or loss. Now we look at what is malpractice. It's a specific type of negligence committed by a licensed professional, such as a nurse or a doctor. Malpractice occurs when a professional failed to meet the standard of care in their field and harm results. So some example in negligence: forgetting to put up the side rail and a patient falls off the bed. That's negligence. And what is malpractice? Administering the wrong medication dose due to failing to follow 5 rights of medication administration, causing the patient harm. Now we know it's now 10 rights of medication administration. So reducing nurses' legal liability. How do we do it? Nurses can take many steps to protect themselves legally and professionally. We can follow standard of care, so adhere to hospital policy, procedures, and State Nurse Practice Act. Maintain competency, stay updated throughout continuing education and certification, even post graduate. You continue learning. Nursing is ever evolving. So effective communication with patient, family, and the healthcare team. Clarify order, especially if unclear or potentially unsafe. And then of course, proper documentation. chart accurately, completely, and promptly. Avoid late entry, erasures, or alteration. Then we want to obtain informed consent, ensure patient understand the procedure, advocate for their rights, and delegate safely. Use the 5 rights of delegation and ensure to follow up. Maintain professional boundary by avoiding dual relationship or behavior that could be misinterpreted. So, key healthcare law affecting nursing. Nurse Practice Act. This defines nurses' role, licensing, scope per state. American with Disability Act prohibits disability based on discrimination. And then Comprehensive Drug Abuse Prevention and Control Act regulate controlled substances. Emergency Medical Treatment and Active Labor Act require hospital to screen and stabilize emergency patients. Occupational Safety and Health Act ensures safe working condition, example, sharps and safety. Healthcare Quality Improvement Act protect peer review process to improve care quality. National Labor Relation Act grants workers the right to unionize. And then Newborn Mother and Health Protection Acts guarantee minimum hospital stay for childbirth. Patient Self-Determination Act require information and documentation of advance directive. Mental Health Priority Act ensure equal mental health coverage. National Organ Transplant Act regulates the organ procurement transfer. So now we'll look at them a little bit closer. The Nurse Practice Act, what is it? It's state-specific law governing nursing practice. The purpose is to define the scope of practice, license requirement, and disciplinary procedure for nurses. The relevance is to know and follow your state Nurse Practice Act. Violating it can result in license suspension and revocation. American with Disability Act of 1990. The purpose prohibits discrimination against people with disability in employment, public services, and healthcare. The relevant to nurses provide reasonable accommodation, example, interpreter, mobility aids, etc. It ensures equal access to care. Comprehensive Drug Abuse Prevention and Control Act of 1970, including the Controlled Substance Acts, regulates the manufacture, prescription, and distribution of controlled substance. Is relevant to nurses is safely store, administer, and document use of narcotic and scheduled drugs. For us to follow protocol for drug disposal and count. Emergency Medical Treatment and Labor Act of 1986. The purpose requires hospital to provide emergency care regardless of the patient insurance or ability to pay. The relevant for nurses is must triage, of course, assess and stabilize all ER patients, cannot refuse or delay care due to financial status. Occupational Safety and Health Act, OSHA of 1970, ensure safe working condition for employees through regulation and inspection. Relevance to nurses. Follow protocol for infection control, PPE use, and workplace safety. Report hazard or injury to supervisor or OSHA. Healthcare Quality Improvement Act of 1986. Encourage peer review of medical professional and protect review from legal liability. Relevance to nurses. Support reporting of unsafe or incompetent nurse. Nurses may participate in peer review without fear of retaliation if done in good faith. National Labor Relation Act of 1935. The purpose is to protect the rights of employee to form union, engage in collective bargaining, and take concerted action. And then relevance to the nurses. Nurse in unionized workplace can negotiate for better staffing, wages, and condition. Employers cannot retaliate against legal union activity. And then the Newborn and Mother Health Protection Act of 1996 requires health plan to cover at least 48 hours of hospital stay after vaginal delivery and 96 hours after a cesarean delivery. So the relevant to nurses is to ensure mother and baby receive standard postnatal care and to educate families about their postpartum coverage right. Patient Self-Determination Act of 1990 requires healthcare facility to inform patient of their rights to make decisions about their care, including advance directive. And relevance is to educate and assist patient in creating living wills or DNR orders, advocate for patient autonomy and wishes. Mental Health Priority and Addiction Equity Act of 2008 requires equal insurance coverage for mental health and substance use disorder for physical health. So as relevant to nurses, support advocacy for patients seeking mental health services, help reduce stigma and barriers to mental health. The National Organ Transplant Act of 1984 regulate organ donation and prohibit the sale of organ. Nurses may, relevant to nurses, may participate in organ donation referral, must follow law and protocol for brain death determination and donor consent. So liability protection for nurses. Safe harbor protection. Legal protection when refusing unsafe assignment in good faith. Whistleblower law. Safeguard nurses reporting unsafe or illegal practice from retaliation. Safeguarding valuables policies to log and secure patient property, preventing loss and theft. Sexual harassment policy. Zero tolerance policy for staff and patient interaction. And professional liability insurance, malpractice insurance to cover claim and legal defense. So coverage for malpractice claim and legal defense support for nurses. Good Samaritan law. Definition. These laws protect volunteers who provide emergency care outside professional setting as long as they act in good faith. So protection action care must be voluntary, emergency based, without compensation, and within scope of training. Exemption. No protection if gross negligence, out of scope of action, or professional setting involved. So the Good Samaritan law are state law designed to protect individuals, including nurses and other healthcare providers, who voluntarily give emergency care outside of a clinical setting from being sued of unintentional injury or harm. The purpose is to encourage people, including medical professionals, to help in emergencies without fear of legal liability. Scope applies when care is given voluntarily, in good faith, outside of paid duty or employee setting, in an emergency situation without gross negligence or willful misconduct. A protected action. You are legally protected under most Good Samaritan law if you render basic emergency care, so example CPR or first aid, at the scene of an accident, and of course without receiving payment or for your help. You act within the scope of your training. So example, a nurse shouldn't be performing surgery on the roadside, and do not abandon the patient after beginning care until a proper help arrives. So example of protected situation is a nurse performs CPR on a stranger who collapsed in public place. A passerby used an AED at an airport. A doctor helped deliver a baby on an airplane during a flight or a flight emergency. So some exception is you may not be protected if you were grossly negligent. So for example, reckless or dangerous care. So given the wrong medication, ignoring bleeding. And then you were intoxicated or impaired, under influence while giving care. And then you were expecting compensation, like payment was offered or expected for your help. So these are exemptions. So you're not protected. You abandoned the person. You stop helping before, or you stop helping before EMS or proper help arrives. You acted outside of your training, like doing a procedure beyond your legal scope of practice. On these cases, the law will not protect you. Next, we look at incident reporting and then mandatory reporting law. So incident reporting, what and when. Confidential internal report documenting accident, errors, or unexpected events, for example, medication error. Required information such as the date, the time, location, individual involved, description, witness, nursing intervention, and outcome. These are required information. And storage, you keep separately from medical chart. Of course, you do not put it in the chart. And it's basically aimed at quality improvement. So just to look at failure analysis, so it's like for risk management and prevention of reoccurrence. So they utilize the incident report to improve care. So just to look at it, purpose of incident reporting. Incident report are confidential. Is document used to record accident and errors in healthcare for quality improvement and risk management. Scope of mandatory reporting law. So law require healthcare professional to report abuse, communicable disease, and elder neglect to protect vulnerable population. Essential report content. So report must include detailed patient information and specifics of the incident to ensure accurate and actionable data. Designated reporting agency, like you report are submitted to the state agency like Adult and Child Protective Services for investigation and legal compliance. So in mandatory reporting law, as I mentioned, this is law requiring reporting of abuse, communicable disease, elder neglect, and so on. And patient information, incident detail, and location and timing is the required content that is supposed to be documented, and you want to report it to the state agency like the Adult Protective Services, Child Protective Services, or other public health department. In mandatory reporting, it requires a certain professional like a nurse to report suspect or known abuse, neglect, or exploitation of vulnerable individual to the appropriate authorities. These laws vary by state but are in place to protect health and safety of children, elder, and dependent adult. So who must report? Typically the nurse, the doctor, the social worker, teachers, law enforcement officers. These are mandatory reporters. Other licensed professional working with vulnerable population as well. You do not need to prove or justify a reasonable suspicion of the harm to report it. If you suspect, you report. What must be reported? Required content of the report usually include child abuse or neglect, like physical, sexual, emotional abuse, abandonment, failure to provide basic needs. And then for elderly abuse or neglect, such as like financial exploitation, physical harm, poor hygiene, malnourishment. And then abuse of a dependent adult, so abuse in group home, long-term care, or by caregiver. Domestic violence in some states, so injury caused by intimate partner violence, and then certain injuries or coordination, like for example gunshot wound, stabbing wound, communicable disease as required by the public health law. So required information including the report, while specified vary by state. While it might be specified or vary by state, report often include your name and professional role. Some states allow anonymous reporters. The victim name, age, and address and contact information should be included. Detail of the suspected abuse or neglect, like type, when, and where. Name of the suspected abuser if it is known. Description of your observations, you describe what you see. Immediate risk to the person if there's any. Document what you saw, heard, or were told. No opinion is to be included. You want to know where, who to report to. So when you're reporting, you want to know who and where you're reporting. So if it's child abuse, you want to report to Child Protective Services or State Child Welfare Agency. If it's elderly abuse, you want to elderly adults abuse, you want to report to Adult Protective Services, APS, or long-term care, the ombudsman. So if it's an injury or crime, you want to report to law enforcement per facility policy. And then for infectious diseases, you want to report to local state public health department. And then within the facility, also report to the chain of command, such as the supervisor or the nurse manager, and follow internal reporting policy. There are legal protection for reporters, so immunity from liability if reporting is done in good faith, and then protection for retaliation at work. So failure to report can lead to fines, loss of a license, and criminal charges in some cases. So you can also face a fine or a loss of license and criminal charges in some cases for failure to report. HIPAA, Patient Rights and Informed Consent. In healthcare system, confidential information security refer to protection of privacy of the client's PHI. Clients have a right to privacy in healthcare system. A special relationship exists between the client and the nurse, in which information discussed is not shared with a third party who is not directly involved in the client care. A violation of privacy occurs in various ways. The nurse's responsibility are bound to protect the client confidentiality by most Nurse Practice Act, by ethical principle and standards, and by institution and agency policies and procedure. Disclosure of confidential information exposes the nurse to liability for invasion of the client's privacy. The nurse needs to protect the client from indiscriminate disclosure of health information that may cause harm. So HIPAA and PHI. HIPAA enforces standards to protect patient health information. The goal is privacy and security and portability. In the medical record, documents patient care include assessment and order. Also in PHI, there's identified information and all across the document, including name, date of birth, diagnosis, social security number, etc. When accessed by a third party, it requires the patient authorization, and without this, it may permit for payments, legal reprimand, and also this pushes the patient as exposure. So must have authorization from the patient in order to allow a third party to access the patient or the person's information. Nurses are to follow disclosure rules and protect the records and also the patient confidentiality. So in the case of social media and PHI, the nurses is not to share any identified patient information on any social media or PHI. They must use strong when they are implementing a security password for a PHI or EMR. It's recommended that The individual uses strong password in order to eliminate access to their information or patient information, and make sure when sending or emailing information utilizing the web or other electronic shared of information, that it is encrypted and is protected. So patient rights and in mental health, when it comes to mental health, which is going to be the next topic. Patient care partnership as well is going to be another topic coming up. But in patient partnership, updated patient bill of rights focus on dignity, information, protection, consent, privacy, timely care, and ethical billing. And we're going to go a little bit in more detail when it comes to these particular topics. So the overview is going to look at mental health competency hearing, legal rights of the patients, informed consent, as well as consent for minors, including emancipated minors, and so on. Patient rights, mental health, and informed consent. Patient care partnership and protective law, as I mentioned, we will talk about this. So patient care partnership overview. The patient care partnership updates the patient bill of rights, emphasizing dignity, comprehensive information, patient participation, informed consent, privacy, timely care, and ethical billing. Key protective law includes laws such as HIPAA, the ADA, EMTLA, and Nurse Practice Act, protect patient privacy, prevent discrimination, ensure emergency care, and uphold professional standard. So patient care partnership focus on dignity, informed participation, consent, privacy, access to timely care, and fair billing. And as I already highlighted, the protective law and mental health competency hearing, which we will discuss at some point. So what is competency hearing really? Let's look at that. Competency hearing assesses whether a person understands the nature and purpose of legal proceeding against them, can consult with their attorney. They have the right to consult with their attorney with a reasonable degree of rational understanding. This is different from the insanity defense, so which addresses the defendant's mental state at the time of the crime. So competency relates to their mental state during the legal process. And then the most commonly used standard in the U.S. when they talk about legal standard comes from the Supreme Court case Dusky versus the United States, which require that the defendant has a rational and factual understanding of the proceeding, has the ability to consult with a lawyer with a reasonable degree of understanding. When is a competency hearing held? A hearing is typically ordered when the defense attorney or the prosecutor or judge suspect the defendant may be mentally unfit, there's evidence of a mental illness, intellectual disability, or behavioral issue interfering with the understanding. So competency evaluation order. A mental health expert, like for example, a psychiatrist or psychologist, is appointed to evaluate the defendant, and then the evaluation report is submitted. The evaluator then gives their finding to the court whether the defendant is competent or not competent. So the judge reviewed the evidence, both sides, when it comes to the competency hearing. Defense and prosecutor may present expert or question the evaluator. The judge decides on whether or not the competency is valid. If the client is competent, legal proceeding continue. If the client is incompetent, the person is usually sent for treatment or education. So sometimes this is typically will occur at a psychiatric facility until they are deemed restored to competency. So what happens if the person never become competent? If a defendant cannot be restored to competency after a reasonable period, charge may be dismissed. The person might be civilly committed if they are considered dangerous. State vary on time limit and procedure. So what are the rights during competency hearing? So the person has a right to counsel, right to independent expert in some jurisdiction, of course, and then right to contest the finding. So what are some legal rights of the patient? They have a right to informed consent and privacy. They have a right to disclosure, so only minimum necessary information shared without patient consent can be done. So just a minimum. And then also legal rights of patient include forced medication. So this is permissible only by court order, or if the patient is in an immediate danger under legal standards. So those are the only time that forced medication may be permissible. So only by court order, or if the patient is in immediate danger under legal standard. Mental health competency hearing. What is the definition? And of course, I'm repeating myself here. Mental health competency hearing evaluate a patient capacity to make informed decision about their mental health care, ensuring they understand treatment implications, legal process for decision making. This hearing review clinical and legal evidence to determine if the patient can make valid decision or require a surrogate decision maker. Implication for patient rights. The hearing outcome affect the patient right, potentially limiting consent ability or affirming the right to informed consent and privacy. Balancing dignity and safety. The process balances patient dignity with safety, ensuring ethical and legal standards are maintained in mental health care decision. So legal process for decision making. Typically initiated by a healthcare provider, legal representative, or family member who observe that the individual may lack decision making capacity. And then if a petition is filed with the court requesting a competency evaluation. In psychiatric evaluation, a qualified mental health professional now conducts a psychological evaluation to assess the ability to understand information, ability to appreciate consequences, logical reasoning, communication of choice. In court hearing, the judge review the medical testimony, the expert opinion, witness accounts. The individual has a right to, or the respondent has a right to, of course, legal representation. Present evidence. They can present evidence for themselves, and they can be cross-examined by witnesses. So in the decision, if found competent, the person continue to make their own decision. As I mentioned before, if they are found incompetent by the court, they can be appointed a guardian or ordered involuntary treatment such as hospitalization and medication. They still have right to informed consent and privacy, even during mental health proceeding. Individual retain fundamental rights. So when you look at informed consent, it must be provided before treatment, unless there's an emergency or legal order. So they must still get informed consent before treatment unless there's an emergency or legal order. And the patient must, of course, understand what the procedure is all about. They must understand their diagnosis, their treatment option. They must also still understand the risk and the benefit, and they also have a right to refuse. So when you think of privacy, such as HIPAA in the US, So medical and psychiatric records are also definitely confidential. Disclosure only allowed with patient consent or by court order, in case of danger to self and others. So every patient has their right to be treated with dignity, meaning we must respect their autonomy and personal a personal identity, while at the same time considering their safety and protection from harm to self or others. We must first utilize the least restrictive alternative and implement involuntary treatment when necessary. In addition, the patient has a right to refuse treatment. However, with regards to patient safety in this setting, we will focus on forced intervention if patient lacks the capacity. Court and healthcare providers aim to use least restrictive measures necessary and ensure decisions are justified and reviewed regularly. So standard maintained in mental health care decisions. So best interest standard. Decision or made in the best interest of the individual when they cannot decide for themselves. In the substitute judgment standard, the decision makers try to replicate what the person would have decided if competent. So when you have a substitute judgment standard, and a decision must be made, the maker tries to replicate what the person would have decided if they were competent. And some clinical guideline and legal status. So mental health provider must follow the DSM-5 diagnostic criteria, local mental health laws, ethical standard from medical board and associations. Of course, there are periodic overview in situations like this. So competency status must be reevaluated on a regular basis. Guardianship or treatment order should not be indefinite. So this can be changed if there are changes. And then, so when we think of mental health competency hearing, we ensure a legal safeguard for the individual with the mental illness by evaluating their capacity to make decisions, protecting their rights to informed consent and privacy, and carefully balancing their autonomy with safety. The process must be fair, it must be evidence-based, and guided by ethical and legal standard to uphold the human dignity or the person's rights. Legal rights of patients. So as I mentioned, that I would be repeating, so informed consent and privacy. Patients have the legal right to be carefully informed about their medical care and to consent voluntarily. Privacy law protects their personal health information from unauthorized access. Limitation on informed disclosure. Patient information disclosure is restricted to clinical necessity and authorized party, ensuring confidentiality except when essential for care. Or authorized by the patient. Condition for forced medication. So forced medication is allowed only under strict legal condition, such as court or when patient poses danger to themselves or others, and balancing safety and autonomy, of course. Informed consents, definition and elements. So some core elements of informed consents. Informed consents include disclosure, comprehension, competence. It must be a voluntary choice, an explicit agreement by the patient. Disclosure requirement: patient must receive sufficient information about diagnosis, treatment option, risk, benefit, and must have alternatives explained to them. Significance of valid consent. Valid consents uphold the patient's autonomy, dignity, and participation, formally ethical basis of medical practice. So who may consent? Competent adult, legal representative, and of course certain minors as well can also consent. Roles and responsibility. The nurse's role when it comes to informed consent. The nurses are to ensure patient complete understanding, witness voluntary agreement, clarify any questions, and alert the provider to concerns about the patient's understanding if one does arise. The provider's role is to disclose and explain all relevant information to the patient, including the diagnosis, the risk, the benefit, and any alternative that enable the patient or the individual to make an informed and valid decision. So as I mentioned before, responsibility of the nurse is just basically to reinforce the information, to clarify what the provider explained within, of course, their scope, provide emotional support to the patient, and then, of course, assesses the understanding and volunteerness of the patient by observing the patient's behavior and respond. And then if there is concerns, you want to report concerns if the patient appears confused or pressured or incapable. Next, the nurse witnesses the signature. In many cases, nurses does witnesses the patient signing the consent form. Witnessing just means that you're verifying who signs the consent. Not that the patient fully understands the diagnosis and the reasons behind it, but you want to make sure that they you witness and verify who signs it. Then you want to advocate for your patient. If you believe, or if the nurse believes the patient does not understand, they must advocate by pausing the process and inform the provider that more explanation or reinforcement or teaching is needed. Then you want to document that the consent form was signed, witness, and any concern that were addressed. Some special consideration when it comes to informed consent in situation like emergency situation. This may allow for implied consent, and then in minor or individual lacking the capacity, consent from a legal guardian or healthcare proxy may suffice. And then in situation with like mental health patient, they must still be assessed for decision-making capacity. Even those under psychiatric care can often provide informed consent. And then, of course, collaboration between the nurse and the provider. The provider does lead the consent discussion and ensure legality, and the nurse supports the patient, monitor for ethical concerns, and uphold the patient rights and autonomy. So changing or revoking consent. So patient does have the right to change or revoke their consent, and this is, of course, a fundamental right in all areas of healthcare, including mental health. This is to ensure respect for autonomy, dignity, and legal protection. So just break it down, some details of the topic across legality and ethical and practical dimension. So when you talk about changing or revoking consent, consent is not static. So patients have legal and ethical right to modify the consent. So at any point in time, they can revoke the consent or withdraw their permission altogether. And if they want to modify, they can change treatment preferences. And then this also applies even after consent has been previously given, as long as the patient is deemed competent at the time of the revocation. So patient rights to modify or revoke consent is, as I mentioned, is their legal rights. They can withdraw at any time. As long as they're a competent adult, they can refuse or stop the treatment, even if it's a life saving treatment. This is just except in limited legal exceptions, such as like a court order treatment or emergency. So those are the exceptions. And these include like involuntary treatment order or guardianship where another party makes a decision. We must be sure to respect the patient's autonomy. So revocation of consent must be honored unless the person lacks the capacity. There's imminent risk to self or other. General rules and exceptions when it comes to consent for minors. So minors typically defined as a person under the age of 18. Minors usually cannot legally give informed consent for medical treatment. This right belongs to the parent or the legal guardian. But parent or guardian consent is required in most cases. So for most non-emergency treatments, such as like immunization, medication, parent or guardian must consent on the minor's behalf. So if it's an emergency immunization or medication, a parent or guardian must consent on the minor's behalf, and then nurse must ensure that the consent is obtained from the appropriate legal guardian before proceeding with care. The only exception is when minors can consent for themselves. There are important legal exceptions where minors can legally consent to their own care without parental permission. These vary by state, of course, but commonly include those like the emancipated minor. These are legally treated as adults. They can consent to all medical care. Usually applies if they are married, emancipated, or minors in the military. They are court declared emancipated. They're living independently and self-supporting. So what does a mature minor conclude? What's that? In some states, a mature competent minor, usually 14 to 17, may consent to certain medical treatment if deemed capable by the provider. It's not recognized in every state, of course. And then some emergency situation where consent is not required, most especially if it's going to delay treatment, would cause harm or death to the person. Parent or guardian is unavailable. This would then allow the nurse and the provider to act in the child's or the person's best interest. In most states, minor can consent to specific services such as reproductive health, contraception, pregnancy care. Abortion varies by state, of course. I know we have new rules and regulation when it comes to abortion. And then sexually transmitted infection, testing and treatment for HIV and chlamydia. Then mental health, outpatient counseling or therapy, substance use, treatment for alcohol and drug addiction. So those are in the situation with certain sensitive health services to be considered. So these laws vary by state, so we always follow local regulation and facility policy. When consent is still needed, even if a minor can consent to care, example like STD testing, parental notification may still be required depending on the state law or after care decision. So those are just situation where consent still may be needed, because parental notification may still be required in the event where they may require some STD testing. So the nurse's really legal responsibility is to verify who is legally authorized to give consent, and then educate the minor and the family on rights and exceptions, and then follow facility policies and state law, and then of course maintain confidentiality, especially in sensitive services that is required by law. Special consideration when it comes to emancipated minors and religious refusal. As I mentioned, emancipated minors are under the age of 18 but legally self-supporting, able to consent to medical treatment without parental approval. Then the rights and provider option regarding religious refusal. Patient or guardian may refuse treatment on religious ground. Provider may seek ethical or legal help in emergency to protect the individual life. Emancipated minor, as I mentioned before, legally treated as adult, can consent independently, and these are married minors, minors in the military, those living independently and financially self-supporting, minors declared emancipated by court. So in the public health law, minors can often receive vaccination or testing, such as treatment for infectious disease, without parental consent, especially during public health emergency. Thank you. This is just the second half, or the first half actually, of this presentation, and we're going to move into the second half of it. We look at employee consent in healthcare, definition, differences, ethics, patients, and the patients. Introduction to employee consent, understanding implied consent. So implied consent refers to nonverbal permission for treatment inferred from a person's action or the situation without formal agreement. Some example of employee consent: a patient holds out their arm for blood draw. An unconscious patient is treated in the ER for life-threatening injuries. A patient walks into a clinic and sits for a physical examination. So no formal signature or verbal agreement is given, but the person cooperates or circumstances where implied consents or acceptable. Real life example of an implied consent: patient holding out arm for blood draw, as I mentioned. A patient voluntarily extend their arm for blood collection, indicates implied consent without verbal or written confirmation. Treatment of unconscious patient in emergency: healthcare provider may administer urgent care to unconscious patient under implied consent when explicit permission cannot be obtained. Patient sitting for a physical exam in a clinic is also another example of implied consent. The patient acts of sitting for a physical exam implies consent for routine assessment. No explicit verbal or written agreement at that point. Comparing implied consent and informed consent. Implied consent is assumed through action without formal agreement. Informed consent requires explicit voluntary agreement after full explanation. When it comes to formality and documentation, implied consent is informal with no documentation. And then informed consent is formal and often require written verification. When looking at typical medical uses, implied consent applies to basic or emergency care. Informed consent is needed for surgeries and invasive procedure. We're thinking of patient understanding and ethics. Implied consent may lack full patient awareness, and informed consent prioritize patient's autonomy and informed decision making. So, ethical consideration in implied consent: respecting the patient's autonomy, ensuring patient action generally indicates agreement, seek explicit consent if uncertain, assessing capacity and awareness. So confirm patient consciousness and competence before applying implied consent. Then scope of implied consent: uses implied consent mainly for non-invasive or emergency care requiring immediate action. Cultural sensitivity in consent: clarify assumption to respect cultural difference in interpreting implied consent. Some culture may interpret implied consent behavioral differences, so we want to always clarify when it comes to implied consent. What happens if a client refuses to give consent? We want to respect the patient's autonomy. Patients have fundamental rights to refuse treatment, and healthcare provider must honor this decision despite potential harm. Ensuring informed refusal: it is essential to assess that patient fully understand the risks and the consequences associated with refusing treatment. Document the refusal thoroughly in the medical record and notify the provider. If refusal puts others at risk, example, refusing TB treatment, follow public health law. A competent adult has a right to refuse any treatment, even if it may result in harm or death. Handling inadequate information or patient questions. So what happens if the client is inadequately informed or has questions? Nurses' responsibility in procedure interpretation: the nurse must pause the procedure if the patient are inadequately informed or have questions. Communication with the physician: the nurse should promptly seek clarification from the physician to address the patient concerns. Ensure patient understanding: nurses verify patient comprehension of the procedures detail, risk, benefit, and alternative. Significance of valid informed consents: so consent is valid only if the patient fully understands what they agreed to ethically and legally. And then the informed consent is only valid if the patient understands what they are consenting to. The difference between implied consent and informed consent, I've already went over that. Definition of implied consent is assumed through action or emergency need, and informed consent, voluntary agreement after full explanation. Some formality of implied consent: informal, not written or verbal statement needed, and informed consent is formal, often require written documentation. Used for basic procedures in emergencies and informed consent such surgery, invasive procedures, including anesthesia, and for research purposes, you must get informed consent. Make sure patient understanding is there, even with implied consent, not always fully informed. And so informed consent must understand the risk and the benefit and alternative. And implied consent, you just want to make sure the patient understand what they are implying, consenting to. So if you're drawing blood, you want to know that they know why they're drawing the blood, so on. And of course, implied consent. Upholding the patient autonomy and safety. So healthcare professional must prioritize respect, clear communication, and patient understanding throughout the consent process to uphold the autonomy, ensure the patient's safety and ethical care. Let's talk about advance directive. What is an advance directive? Advance directive are legal documents that allow patient to express their wishes about medical treatment if they become unable to make decision in the future. These are types of advance directive: living will, specify treatment a patient wants or refuse if terminally ill or permanently unconscious. So they specify what type of medical treatment they may want. Then in the endurable power of attorney, a designated, a trusted agent to make a medical decision when the patient is unable to do so. So like a healthcare proxy, for example, they designate a trusted person like an agent to make the medical decision if the patient is not able to. And then DNR, or do not resuscitate order, specify that no CPR or advanced cardiac life support should be given if the person's heart stops. And then PULS, so POLTS, physician order for life sustaining treatment, is a medical order that details desired treatment in emergency. It's often used for serious illness or frail patients. So this is a physician order for life-sustaining treatment. So who can witness advance directive? Witness required for advance directive. Witness must be unbiased adult, typically 18 or older, who are not the patient healthcare agent, direct beneficiary, or healthcare provider. Some state requirement may vary, so we want to make sure we understand the state requirement, regulation, rules, and so on when it comes to advance directive, or when it comes to witnessing, who can witness as well. As I mentioned, witness must be an adult, must be unbiased, so not the patient healthcare agent, not directly person like beneficiary in the will or somebody's estate. It cannot be the healthcare provider that is caring for the patient. And of course, it's varied by state. Legal requirement, Patients Self-Determination Act. This was established in 1990. The Patient Self-Determination Act, where a healthcare facility funded by Medicaid or Medicare must provide written information about advance directive to patient upon admission and inquire about existing directive. Staff must be educated on advance directive and to respect patient rights to make medical decision. So the Patient Self-Determination Act that was established in 1990 requires that all healthcare facility that is Medicaid or Medicare funded must provide written information about advance directive to patient upon admission and inquire about any existing directive or advance directive that might be in place. And of course, staff must be educated on advance directive, and they must respect patient rights to make medical decision. As I mentioned, who do advance directive, or when does advance directive go into effect? When patient is unable to make or communicate decision due to incapacity, serious illness or injury, if the person is in a coma or is unconscious. For DNR, the order must be clearly documented and accessible in medical record. Patient rights to cancel or change advance directive. So, can the patient cancel or change advance directive? Yes. The patient have the right to revise or revoke their advance directive at any time, as long as they are mentally competent to do so. Revocation should be documented and communicated to the healthcare provider and the family. Nurse's role in advance directive. The nurse is to educate the patient and family about what advance directives are, ensure documentation of advance directive in the patient's medical record, advocate for the patient wishes, and ensure care aligns with their directive or what their wishes are, and then to notify the provider and the healthcare team about the existing directive, maintain confidentiality regarding patient directive, and do not give legal advice when it comes to when it comes to these things. We do not give legal advice. Refer to a social worker or legal counsel if needed. DNR comfort care protocol. We focus on providing comfort, pain relief, and dignity rather than life extending measures. And this may include like oxygen therapy, pain medication, emotional support, hygiene, and nutrition as tolerated. Nurses monitor symptoms and provide compassionate care, respecting the patient wishes.